Hello, everyone, and welcome to today's Seed World Strategy webinar. My name is Alex Martin, and I serve as the editor for Seed World, and today I'm so happy to be your host. Today we are looking at a topic that isn't new, and you've probably even heard a lot about it in the news lately. How intellectual property, or IP, plays a role in competition between businesses in the U.S. The most recent thing you probably have heard about in terms of U.S. competition and intellectual property is that on May 11th, the USDA announced that they were opening a commentary period as a result of President Biden's executive order on promoting competition in the American economy to examine competition issues in the economy. And this commentary period was not just on seed, it was also on crop protection and fertilizer. And while that commentary period is over, the question is still kind of in the air about throughout the industry about how to talk about these different factors, especially IP, and how they are affecting competition between seed companies in the US. Today, that's what our expert panelists are going to help us learn. So we have three things on our agenda today. We will be able to understand by the end of this webinar why IP is used in seed companies, the pros and cons of IP laws, and how IP affects competition between businesses. Also, we'd like to let you know that we're going to be live tweeting during today's webinar. So if you'd like to join the conversation, please use the hashtag SWStrategyWebinar to connect with us. Also, we'd like to let you know this webinar is being recorded, so if you miss any part of it, you'll be able to see it online on seedworld.com within the next couple of days. And with that, I'd like to introduce our speakers today. So we are presenting two panelists today, Joel Cape, who is owner of Cape Firm, and Phil Howard, who is professor at Michigan State University and a member of the International Panel of Experts on Sustainable Food Systems. Thanks so much, Joel and Phil, for joining me today. Before we dive into some of my questions, I'd like to get some introductions from both of you. So Joel, I'll let you start. Can you tell us a little bit about yourself and your firm, and just give us a brief introduction?
Sure. I'm an attorney. I've been practicing law for a little over 20 years. The bulk of that has been in the seed industry in one fashion or another. Quite a bit has been in the licensing and enforcement of intellectual property rights. And I currently advise and represent a variety of seed companies and ag input companies in general, sort of in intellectual property matters and just business operations. I'm for what it's worth, I'm based in Fayetteville, Arkansas, and travel, across the country for business to the extent that matters.
Perfect. Thanks so much, Joel, for the introduction. Phil, we'd love to turn it to you. If you want to give us a little bit more about yourself and your research, we'd love to hear it.
Yeah, I teach and research at Michigan State University, which is in East Lansing, Michigan. My background is in rural sociology, and I focus on issues of sustainability and food systems. And I look at both the seed industry and a lot of other industries, and I focus on trends of consolidation and concentration.
Perfect. Thank you so much, Phil. And I forgot to mention to our audience, of course, during this panel, you're probably going to have some questions. Please feel free to send in your questions for Joel or Phil at any time. I'll make sure they get to them, but feel free to ask those whenever you'd like. Until then, let's get started with some questions. So Joel, you've kind of already given us the background. You've worked with IP for a long time in your stint as an attorney, especially with your specialization in agriculture. Can you kind of give us some background information on intellectual property and how it relates to agriculture, why it matters to agriculture?
Sure, I'll try to summarize that. I mean, generally speaking, intellectual property is legal protection for somebody's new novel inventions, new ideas. Not ideas is probably too broad of a term, but it basically provides incentive for people to develop new products, new inventions and things. And in agriculture, relatively speaking, intellectual property might be regarded as somewhat new. Historically speaking, in the seed industry in the United States, for quite a long time, from colonial times, there was no intellectual property protection. Matter of fact, a lot of the crops that we produce domestically were not indigenous to North America. And so for a very long time, there was a free seed program developed by USDA. And then eventually, as people got involved in trying to develop and better the varieties, we had the Plant Patent Act of 1930. And that was limited only to what I'm going to call asexually reproduced plants, for lack of a better way to put it, just call it cuttings, right? Because those were genetically identical to the parent, and they could be reproduced in a stable fashion. And that was the thinking of the day, that seed produced crops, because there was pollination involved, that you couldn't produce them uniformly in a stable fashion. And eventually the technology and understanding developed to where you had the Plant Variety Protection Act. That was intellectual property protection developed and passed by Congress for the protection of seed reproducing plants. And those were the two primary areas. And then eventually we had the Supreme Court decision, Diamond v. Chakrabarty, which affirmed that you can get a utility patent, which is the patent that we all think of. When we think of patent law, it's the patent that protects the light bulb, or the patent that protects the radio, the utility patent. And the Supreme Court had a decision in 1980 that really started laid the groundwork for a lot of the protections that we use in the seed industry today, utility patent. And it affirmed that you could, in fact, patent living material. So that's kind of a little bit of the background of the IP regime that we enjoy in the United States, and which is now extensively used in the seed industry.
Perfect. Thanks so much, Joel. We appreciate that history lesson, because I don't think I would have ever known in my time in the industry that utility patents are relatively new to our industry as well. Phil, I know you come a little bit from outside the law perspective, as you're more focused on food systems in the U.S. What are you seeing in terms of food systems right now? I know you do a lot of work in looking into competition and consolidation in the industry. So what are you seeing right now?
Yeah, we're seeing a lot less competition, a lot more consolidation in many industries, not just seeds, but just about every sector of the food system you look at. There's a trend towards fewer and larger firms, and that's a result of, in many cases, they are being allowed by government regulators to acquire their direct competitors, or in some cases upstream and upstream suppliers, downstream customers. So we have a trend that's occurred really fast in the seed industry. It's been even more dramatic than some others. So to take one really dramatic example in the U.S., over 80% of the market of beef processing is held by just 4 firms. But the seed industry is even more consolidated to looking at it globally, where you have, as of about 10 years ago, just 3 firms controlled about half of the world's market for proprietary seeds.
Perfect. Thank you so much. I think that gives us a good perspective of where we're at right now. And I appreciate that you mentioned it's kind of developed a little bit more rapidly than some other different sectors and situations. Now, Joel, how does IP factor into competition in the U.S. in your opinion? I know you went through the whole discussion of why companies want to look into things like IP, but what are some of the pros and cons of what you're seeing for IP factoring into competition?
Well, fundamentally, intellectual property protection is good. It enables firms and people that are investing time, resources, and effort in developing these things that better our lives to obtain what we typically call a limited monopoly, a limited time within which you can take advantage of your unique effort and gain, financially from it, but, be the only one, so to speak, to be able to use the invention. And, so it's typically 20 years for a utility patent. But those are good things. Those are what has driven the innovation of a lot of the things we enjoy today, and certainly true in the seed industry. The cons would be I guess I'll narrow it down to the seed industry. The cons would be, once the intellectual property is granted, what I perceive is that these rights and the way they're administered are fairly burdensome, and partly because of the consolidation issue that we talked about. These rights are now held by very few firms, and when they're held by very few firms, it really makes it difficult. And these licensing schemes that we now see and today are fairly onerous and difficult for mid-size or smaller firms to handle, or even to take on, or frankly to understand.
Perfect. Thanks so much, Joel, for that information. Phil, to explain, I think, a little bit on this. So you mentioned how the industry is kind of merging together at a rapid rate. Excuse me. Can you tell us a little bit more about those findings? Maybe like why are we seeing such a rapid acquisition and merging of the seed sector?
Yeah, I mean, there are forces that are driving this in many industries, not just seeds, but those increasing intellectual property protections in seeds have played a role. For example, when the Plant Variety Protection Act of 1970 was enacted, that spurred a lot of acquisitions of, in the 1970s, the seed industry in the U.S. was characterized by a lot of mom and pop firms. They were thousands of them that were making a living, but not making a killing. And so the potential of having a government protected monopoly spurred outside industries, oil companies, pharmaceutical companies, grain traders to start acquiring seed companies. And eventually it was the chemical companies that ended up acquiring, well over 200 of the largest seed companies in the world have been combined into these, a handful of firms. And that's because it gives them those innovations that those smaller firms made, but the resources of the bigger firm to take that further, to, take farmers to court and go all the way to the Supreme Court and even increase intellectual property protections even further.
Perfect. Thank you so much. There's a lot of history that goes into this topic that I don't think I realized when I was looking into it, guys. So I appreciate some of the lessons that y'all are sharing with us. Joel, to expand a little bit more off of your last question, I know in particular, as we talk about the USDA addressing competition in seed, crop protection, fertilizer, etc., IP and IP laws were something that came up during the commentary period in some of the questions that the USDA was asking about. Why is this something that the USDA wants to ask a little bit more and kind of prod a little bit more into as they start looking into competition?
Well, I think it is. I think that's a lot about what has been talked about. It's the consolidation is driving a lot of this, and to a large degree, yes, it's been going on for a while, but it was a dramatic. There's been a sort of dramatic change after the introduction of the first biotech traits, and that was kind of a game-changing event, for lack of a better way to put it. And it has led to where we are today, which is these very few firms, and then the rest of the players in the industry are left sort of at their maybe at their mercy might be too strong of a word or way to put it, but they're accessing all of their genetics from very few firms, and they're starting to be sort of a pushback, I guess, maybe a grassroots pushback, for lack of a better way to put it, that people are concerned that they don't have access to traits. And or germplasm. And the notion that you have to have a license to access these materials, and that license really can be a lifeline for a small seed business or a regional seed business. Without that license from these big genetic suppliers, you have no business. And I think that's a really compelling reason why USDA has asked for comment on these issues.
Thanks so much, Joel. That's some great insight, I think. Phil, again, you have a completely outside perspective as a researcher, and I know you've already mentioned that you've seen IP kind of influence some of these changes in the food system. But how have you seen IP influence food systems in the U.S.? What is your research kind of showing you lately?
Yeah, just one example is that farmers, because of the biological barrier of hybridization and the yield gains that came from hybrids, farmers were used to buying corn seed year after year. So they wouldn't save and replant corn in most cases. For soybeans, it was different. There was a biological barrier to producing hybrids, but the introduction of full patent protection on seeds with genetically engineered seeds in 1996 meant that farmers could no longer save and replant those seeds. And some farmers have even gone to prison for saving and replanting seeds, even in cases where they say they never signed a technology agreement, or in cases where they've been fined or lost court cases because they've gone to their local grain elevator and purchased seeds and planted those. So restrictions on seeds are incredibly more restrictive than non-living things that have been innovated. So there are more and more barriers to farmers exchanging seed. And so, some countries have, pushed back against this trend of increasing intellectual property protections. They haven't signed on to international agreements that would be more restrictive. But in many parts of the world, it has been this trend of, taking away some of the freedoms that farmers had not that long ago, and also reducing their choices, because as these firms have gotten larger, they've dismantled divisions, they've dropped brands, they've reduced the number of varieties that are for sale in some cases. So we have less diversity in the food system as a result.
And I know crop diversity is a big discussion even outside the world of IP, especially as you look into food systems and global food systems. I have a question actually for both of you now. To both of you, do you currently see IP as an encourager or a hindrance for competition between seed companies in the U.S.? And why would you think either of your opinions? So I might start with Joel, just because that's been the order we've been going through. But Joel, what do you think? Have you been seeing IP as kind of an encourager or a hindrance lately?
I guess I would say I would take both. And I know it's a wishy-washy answer, but
that's okay.
IP does encourage innovation. I mean, the biotech traits probably would not exist. And I think we would all agree that biotech traits have been a wonderful innovation for commodity crop producers. And maybe not everybody likes them, but certainly farmers do, and a lot of commodity producers do. They are fantastic, and they were enabled by IP law. On the flip side, it's kind of what I was alluded to earlier. These rights, since they've been granted over time, and I think we're really talking about the early 90s up till today, the licensing of these genetics. And I want to be careful when I talk about that, because I'm really focusing on the major row crops. That's where we see this issue play out. Other sectors of the seed industry and I guess horticultural crops and things like that don't experience this to the degree that row crops do. But those licenses have become extremely long and complex and have offloaded, I think, a lot of the burdens onto the smaller players, and onto the people that have the licensees. I'll get to it. The licensees are now responsible for the stewardship requirements, maintaining the production. They take on a lot more risk, but don't get the benefits in return.
Yeah, thanks so much, Joel. Phil, I'd love your opinion as well.
Yeah, I think it's encouraging competition, but increasingly narrow and very limited areas. So the focus on blockbuster traits for those commodity crops, and a focus on the geographic areas where they're grown most extensively, which leaves a lot of other people out. And then when you have, even though you have that competition, when there are successes, those companies are quick to cooperate with each other. So back when we had big six seed chemical firms, there was a web of cross-licensing agreements. So they, shared all of the traits they had developed with each other and were able to stack them into, one seed. And farmers who wanted all those traits benefited, but at the cost of, losing more and more of the competitors in the industry. And I think it's debated, but I think we're seeing a lot less innovation for orphan crops, for non-commodity crops, for geographic areas that aren't a focus of these companies. And this trend is going so far that this could be a real problem for the food system that's going to have to adapt to changes like climate change and trade disruptions and so on.
Yeah, thanks so much, Phil. Joel, I know another thing that was brought up in some of the commentary period for the USDA was the factor of cost coming into play as we move into next generation traits. How have you seen the IP regime change around that area, around the area of the cost of seed or the cost of innovation even?
The costs, I believe the cost of bringing traits to market has remained fairly high, and it's a fairly lengthy regulatory process, and it involves more than just the intellectual property laws. And I guess I'll clarify, talking again about the major row crops and the traits in those row crops: corn, soybean, cotton. The cost of bringing those to market is high. What I think is happening now is, we're taking the first generation traits and tweaking them a bit, and then also stacking first generation traits on top of first generation traits to become a new product. So this stacking concept is essentially maintaining the original benefits, and the high rate of adoption. These are input traits, right? They're all insect tolerance, herbicide tolerance. They're input traits, not necessarily output traits. So something that would be like a trait that would deliver higher vitamins in the end product, or higher nutrients, or something of that nature. The costs of these new traits or new trait stacks keep increasing, but the benefits to the primary user of the traits is roughly the same. It's controlling weeds and insects. And so that, I think, is a detriment to the people that need it the most, which are the farmers that are trying to utilize these traits. They're paying more, but sort of, maintaining just kind of treading water on where they were at when they adopted the first generation traits.
Perfect. Thanks so much, Joel. I actually got in an audience question, and I apologize to Wolf. I've been reading your question and trying to see how I can phrase this for Joel and Phil. And Joel and Phil, I'm not quite certain who to direct this to. So if we don't know the answer to this question, that is absolutely okay too. They would like to know, in your opinion, do you believe that IP protection in plant breeding is the reason for the reduced number of competitive breeding companies, and thus in the much flatter innovation curve compared to Europe, where there's still open source system regarding genetics? It's a little bit about access and benefit sharing, I think. So I apologize. I think I worded it the best that I could.
I'll take a stab at that and just. I think that keep in mind that if someone's applying for a utility patent on genetics, that patent becomes published. It becomes public knowledge, and everyone then has the opportunity to take that knowledge and utilize it at least at the end of the patent period. One of the things that sort of may hinder that a little bit is that the crop cycle oftentimes is a lot quicker than the patent protection cycle, right? So new genetics and new varieties are probably introduced. Well, they're introduced every year, but a good new variety might last for 5 or 6 years, whereas if it's patented, that patent will last for 20. And so, but after the 5 or 6 year period, it's replaced by something newer and better. So that's sort of part of the equation. The other part is that the reduced number of breeding, it depends on what crop you're talking about. And I think that's important to keep in mind. If you're talking about the major row crops, yeah, there's only a handful of places to go if you're going to be a plant breeder and have a career. I mean, that's a limited number of outlets now, and that's a symptom, I think, of the consolidation. But for other crops, I think there's still a lot of opportunities.
Okay, thanks so much, Joel.
Yeah.
Phil, anything to add?
Yeah, one of the things that I've noticed is that, when Monsanto's glyphosate, proprietary glyphosate came off patent, they were still able to maintain an extremely dominant market share for that product at very high prices. And that's because they were tying it to their proprietary seeds. So these patents don't exist in a vacuum. You have to look at how they're tied to each other, the other market controls that these firms have. So one of my questions that I don't know the answer to is, as these patented seeds start to come off patent, is the regulatory environment so complex that it's hindering smaller seed companies from, actually being able to make those seeds more widespread and cheaper? I don't know the answer to that.
Thanks so much, Phil. I think that's a question probably that a lot of us have as well.
I will weigh in just a moment on that.
Sure.
In the traits that I keep mentioning, there's a EPA has a very significant role in these approvals, and that beyond just the obtaining the patent rights or the intellectual property rights, there is a regulatory approval process. And so you might want to think of it in this fashion. If you register a pesticide, the company that registers it submits data. That data is proprietary to the company, and they can withhold it. And there's a system through FIFRA, which is the federal law that provides for registration of pesticides. All of these products are registered or are regulated as pesticides. I say all of them. The insect and herbicide tolerance traits are regulated as pesticides. So they have to go through this FIFRA process, and that data, in order to get access and obtain these Me Too registrations, you have to pay for the original data. And that in a fashion is, I don't know if I would call it intellectual property, but it is in a way. And so you can't access it, and you're not going to be able to unless you pay for it, and the registrants keep it. And the seed industry has a couple of agreements, the DUCA and I don't know, they have these odd names that the majors created, the DUCA and the GECA or something like that, which is this sort of self-policing way. If you want to get access to the data to register these traits, you can enter into these agreements. I don't know that anyone ever has.
Perfect. Thanks so much, Joel, for adding that on. I'm looking at the time. I'm a little bit over on what time I wanted us to end by, but I do still have one last question for both of you. We've been talking about kind of the background of competition and seed and competition and the relationship between IP this entire time. So we've already asked the hard question of whether or not y'all think IP is a hindrance or encouraging innovation. But I also want to ask, do you think there need to be any changes in the realm of IP when it comes to seed and seed traits? Phil, I might direct this question to you first, just because we've been talking to Joel first a lot, and I'll give you a chance to talk first, but I'd love to hear if you have any opinions on that.
Yeah, I think going from patent-like protections that allowed farmers to save and exchange seed and replant seed to full patent protection, which restricted all this, I think that was too far. I don't think there should be patents on living organisms.
Thanks so much, Phil. And Joel, any opinions from you on that perspective, or on that question?
I had a couple of comments that I made in the submission to the USDA's comment period, and I think it would be useful, at least in the seed context, to look at other examples that we have in agriculture and that impact these practices. Packers and Stockyards Act is one. Perishable Ag Commodities Act is another. They have within those acts a basic concept of they recognize that there are players in the market that, because of where they are and their position, have the ability to be onerous, burdensome, maybe even unfair in the way they deal with the other participants in the market, certainly the least powerful. And I think we can take some of those basic concepts and apply them here in the administration of seed-related IP, particularly after it comes off patent. But even while it's on patent in these licensing practices, I think we could take some of those lessons of basic, fair practices, fair marketing, and fair licensing and apply them here.
Thanks so much, Joel. Well, I think with that was my last question I actually had for you both today. And we are about 5 minutes over on our time. So I think that's where we're gonna wrap up today. So Phil, thank you for coming on and giving us your information about how you're seeing changes in the seed industry when it comes to consolidation. Joel, thanks for bringing your IP expertise on as well. And I hope you and the audience were able to find something of value to take home and be able to learn or think about later tonight at the dinner table. Just a reminder, we wanted to let you know that if you missed any part of this webinar and would like to go back and review it, a webinar recording will be made available later this week on seedworld.com, so be on the lookout for that. Thanks again so much, everyone, and we hope you have a fantastic rest of your day. This is Alex Martin of Seed World signing off. Thanks, everyone.